Good afternoon. Today I'll be sharing with you some of the upcoming changes to the Companies Act. In October of this year, Parliament passed a Companies Amendment Bill which proposes the largest number of changes to the Companies Act since the enactment of the Companies Act in 1967. Most of these changes arose from a steering committee that comprises senior public and private sector members and which was appointed by the Ministry of Finance. Other changes are also being made, including those relating to foreign companies, which are also regulated under the Companies Act. The objective of the changes are to reduce regulatory burden, to give greater business flexibility, and to improve the corporate governance landscape in Singapore. The amendments are likely to take effect in the first quarter of 2015. The following are the highlights of the changes which I will be mentioning in respect of local companies. First, the small company concept for audit exemption, the revised financial reporting requirements for dormant companies, the use of alternate addresses on ACRA's records, ACRA's electronic register of members and register of directors, the merger of the memorandum and articles into a single document known as the Constitution, new disclosure requirements for CEOs, the removal of the one share, one vote restriction for public companies, introduction of multiple proxies to enfranchise indirect investors, updates to the striking off regime for local companies, and the registrar's new powers to debar directors and company secretaries. I'll start first with the small company audit exemption. Currently, exempt private companies which have an annual revenue of 5 million or less are exempted from the statutory audit requirement. Going forward, this will be replaced by a new small company criteria for audit exemption. A small company would be one which is a private company and which meets 2 out of the 3 following criteria for the immediate past 2 financial years. The 3 criteria are total annual revenue of not more than 10 million, total assets of not more than 10 million, and number of employees not more than 50. For a company which is part of a group of companies, in order to qualify for the audit exemption, the company must not only itself qualify as a small company, but the entire group to which it belongs also has to qualify as a small group. For the group of companies to qualify as a small group, it has to meet at least 2 out of the 3 quantitative criteria which I mentioned earlier on a consolidated basis for the immediate past 2 consecutive financial years. Once a company has qualified for the audit exemption as a small company, it will continue as a small company until it is disqualified. And how would a small company be disqualified? That would be if it ceases to be a private company at any time during a financial year, or if it does not meet at least 2 out of the 3 quantitative criteria for the immediate past 2 consecutive financial years. Similarly, for the small group status, it will also continue until the group does not meet at least 2 out of the 3 quantitative criteria for the immediate past 2 consecutive financial years. When will this new audit exemption take effect? It would be applicable for financial years commencing on or after the effective date of the amendments to the law. Transitional provisions will be provided for existing companies. For such companies, they would be able to qualify during the first 2 financial years after the commencement of the amendments, if the company is a private company and meets 2 out of the 3 quantitative criteria either in the first or the second year after the commencement of the changes to the law. Special provisions will also be provided in respect of new companies. They would be able to qualify as small companies in the first or the second year of their existence if they are a private company and if they meet 2 out of the 3 quantitative criteria in either the first or its second year of existence. I've included an illustration to show you how the small company criteria would work in practice. And I've chosen the financial year 2020 because this would be outside of the transition period. So this would be the application, the general application of the small company criteria. So for a company to determine whether or not it is a small company in the year 2020, it would have to determine whether or not it is a private company in the year 2020 and whether it meets 2 out of the 3 quantitative criteria in the previous 2 consecutive financial years, that is 2018 and 2019. If the company does qualify as a small company in the year 2020, it will continue to be so for subsequent financial years until it is disqualified. And it will become disqualified if it ceases to be a private company in any any subsequent financial year, or if it fails to meet at least 2 out of 3 quantitative criteria in the immediate past 2 consecutive financial years. The introduction of the new small company audit exemption is intended to reduce the regulatory costs for smaller companies that do not have a wide market impact. It also recognizes a broader group of stakeholders other than just shareholders and is similar to criteria that is used for differentiated financial reporting in other countries. I now move on to updates relating to the financial reporting requirements for dormant companies. Currently, a dormant company is exempted from the statutory audit requirements, but is still required to prepare accounts. Going forward, dormant non-listed companies, other than subsidiaries of listed companies, will be exempt from the requirement to prepare accounts. The exemption from preparation of accounts is subject to a substantial assets threshold test. That means the company's total assets cannot be more than $500,000 in value. A company with assets which are more than this threshold will be treated the same way as listed companies. There will be no change in respect of the regime for listed companies and their subsidiaries. This would mean that the company would be exempt from the statutory audit requirement, but it must still prepare its accounts. These changes would reduce the regulatory costs for dormant companies which have a lower public impact. I now move on to the use of alternate addresses. Currently, individuals are required to report certain personal particulars with ACRA, and this would include their residential address. The information is made available to the public. Going forward, we will allow the reporting of an alternate address where a person can be located instead of the reporting of a residential address. The alternate address cannot be a PO box and is limited to 1 alternate address per person, and that alternate address has to be within the same jurisdiction as the residential address. If a person wishes to make use of an alternate address, he will still have to provide a residential address to ACRA. And should it be shown that the alternate address that has been given to us is inaccurate, we will then publish the residential address on our records after giving that individual an opportunity to make representations. Such a person will also be barred from using alternate addresses for 3 years. This new alternate address policy will help to give greater privacy to individuals who have reservations about having their residential addresses on ACRA's public records. I now move on to the requirements relating to registers which have to be maintained by companies. Currently, all companies are required to maintain a register of member at their registered office. Going forward, ACRA will update and maintain an electronic register of members for private companies. Companies will have to register share ownership changes with ACRA, and this would be real-time registration, which would mean that the filing date would be the effective date for membership or cessation. In order to facilitate the real-time registration, companies may prepare the registration details a week in advance, save these as drafts, and then file them at the appropriate time. ACRA's register of members will be made available to the public for a fee, but there will be no charge for access by the company. Companies will still be required to keep its register of members as at the time of the change of the law until the retention period expires, and this statutory retention period is 7 years after the last member on that register of member ceases membership. These changes will help to streamline the administrative processes for companies and will also give the public greater access to information on these registers. In a similar vein, there is also a requirement for companies to maintain registers of directors, secretaries, auditors, and managers. And going forward, ACRA will be updating and maintaining these registers, the electronic registers relating to directors, secretaries, auditors, and CEOs. Companies will be required to update ACRA within 14 days of any changes that would affect information on these registers. I would like to highlight that there will be a change in ACRA's records from a manager to a CEO. This would mean that a manager that was incorporated before the changes to the law will be treated as a CEO. And where the names or particulars of managers have been previously reported with ACRA, these names and particulars of the managers will be entered into the register of CEOs as CEOs until any notification of change is made by the company to ACRA. Again, these changes are intended to streamline administrative processes for companies, and the public will be given greater access to information on these registers. I now come to the merger of the memorandum and articles into a single document known as the Constitution. Currently, in order to incorporate a company, a person will need to register a memorandum and articles of the company with the registrar for registration or incorporation of the company. And the articles can adopt all or any of the regulations that are contained in the current Table A of the 4th Schedule to the Companies Act. Going forward, the memorandums and articles of a company will be merged into a single document, which would be referred to as the Constitution. We will be prescribing model constitutions by way of regulations. A company can choose to adopt the whole of a model constitution for the type of the company to which it belongs, and to adopt the model constitution in force at a particular time, or a model constitution that's in force from time to time. If the whole of the model constitution is adopted, there will be no need to file a constitution with ACRA, and you would only need to refer to the title of the model constitution which has been chosen. However, if the company chooses to adopt only part of the model constitution or adds on provisions to it, it will have to file the constitution with ACRA for the purposes of registration. Again, these changes are intended to streamline administrative processes for registration of companies. Next, new disclosure requirements for CEOs. Currently, directors of companies are required to disclose conflicts of interest in transactions and shareholdings in companies and related corporations. Going forward, these disclosure requirements will be extended to CEOs of all companies. For companies of for CEOs of non-listed companies, however, the disclosures relating to shareholders will exclude securities of related corporations and participatory interests made available by the company or its related corporations. These are in line with the disclosures that are required for CEOs of listed companies. The disclosure requirements in relation to directors are being extended to CEOs in recognition of the significance of the CEO's role at the apex of management of the company and in decision-making. It will also help to improve transparency and to promote better corporate governance. Next, the removal of the one share, one vote restriction for public companies. Currently, public companies may only issue shares with one vote per share, except in the case of preference shares. This restriction will be removed and safeguards will be introduced. The safeguards would include that the directors have to approve the issuance of shares with different voting rights by way of a special resolution, which requires a 75% approval threshold. The information relating to voting rights of each class of shares will need to accompany any notice of meeting at which such a resolution will be tabled. The rights of shares will have to be specified in the constitutions of the companies and clearly demarcated such that shareholders will know the rights that are attached to each class of shares. And holders of non-voting shares will have equal voting rights on resolutions which relate to the winding up of the company and variation of rights for non-voting shares. At the outset, these changes will only be applicable to public unlisted companies. For listed companies, SGX's existing policy of not allowing existing voting rights will continue to apply, pending conclusion of further review. The removal of this restriction will help to give companies greater flexibility in capital management and will give investors a wider range of investment opportunities. It's also similar to the positions in the UK, New Zealand, and Australia, which allow shares with different voting rights. However, Australia does restrict listed companies by way of its listing rules. Next, the introduction of multiple proxies to better enfranchise indirect investors. Currently, unless the articles of a company allow, the member can only appoint up to a maximum of 2 proxies, and proxies are only able to vote by way of poll. There is a 48-hour cut-off time for the submission of a proxy form. Going forward, specified intermediaries will be able to appoint more than 2 proxies. The intermediaries that are specified are custodian banks and nominee companies that are subsidiaries of banks, other persons licensed to provide custodial services to investors, and the CPF board. Proxies who are appointed by such intermediaries will be allowed to vote on a show of hands. And the cut-off time for the submission of proxy forms will be extended from 48 hours to 72 hours. We note that companies that might have a large number of indirect shareholders may require some time to adapt to these new changes. This grace period will be given for such companies to work out new procedures. The introduction of multiple proxies will help to facilitate indirect investors in attending shareholders' meetings as proxies and to allow them to vote by way of a show of hands. These changes will help to enhance corporate governance and encourage shareholders' participation. And the longer cut-off time that I mentioned will give companies more lead time to be able to process the proxy submissions and to handle other administrative matters due to the increase in the number of proxies. I shall now move on to the updating of the striking off regime for local companies. Currently, where the registrar has reasonable cause to believe that a company is not carrying on business, it can initiate a process to strike off a company. This will be done by way of sending a notice to the company, and where the registrar does not receive an answer within a month, he may then publish in the Gazette a notice and publish in the Gazette and give the company a notice that on the expiration of 3 months, the company will be struck off. Any person that's aggrieved by the striking off of a company can appeal to the court within 15 years of the striking off for the restoration of the company. These are some of the key changes that are being made to the striking off regime. Firstly, the period of objections or for showing cause has been reduced from 3 months to 60 days. The period of appeal to the court for restoration has also been reduced from 15 years to 6 years. The Act going forward has also been clarified to make a clear distinction between the provisions relating to a company's application for striking off and striking off that is initiated by the registrar. The procedures, however, for the notification and for the objection process will remain similar for both types of striking off. The registrar will be empowered to administratively restore a struck-off company where the striking off was initiated by the registrar. The application has to be made within 6 years of dissolution of the company. The registrar will also be empowered to restore a company which has been struck off by the registrar's mistake. This excludes striking off on the basis of wrong, false, or misleading information that has been given by an applicant where the company applies for striking off. The shortening of the restoration period that I mentioned for appealing to the court for restoration from 15 years to 6 years is for greater consistency with the limitation period for the recovery of debts. And the new procedures that have been put in place for administrative restoration by the registrar will help to reduce costs for applications for restoration. The last change I'll be highlighting for local companies is the new powers of the registrar to debar directors and company secretaries. The registrar will be empowered to debar any director or company secretary of a company that has failed to lodge any documents at least 3 months after the prescribed deadlines. A debarred person cannot take on new appointments as a director or a company secretary, but he may still continue with his existing appointments. The registrar will lift the debarment order when default has been rectified or on other grounds that we will be prescribing by way of regulations. These new powers will help to prevent irresponsible directors and company secretaries from holding similar positions in other companies, and will also help to promote greater compliance with filing requirements. I shall now move on to highlight some of the changes relating to foreign companies. These are a reduction in the number of agents, renaming of the agents to authorized representatives, alignment of the financial reporting requirements with those relating to locally incorporated companies, and expanding the grounds for striking off of foreign companies. Currently, a foreign company is required to have at least 2 locally resident agents. Going forward, this would be reduced to 1, and the sole agent can only resign where a replacement agent has been appointed. In the event of death of the sole agent, the company must appoint a replacement agent within 21 days. These changes will help to reduce the regulatory burden for foreign companies by reducing the number of agents that it needs to appoint. The agent will also be renamed as an authorized representative. This will better reflect the accountability and responsibility of the role. Next, the alignment of the financial reporting requirements for foreign companies with those of local companies. Currently, a foreign company is required to file a balance sheet and any documents that are required to be prepared in the place of registration. The test is whether or not the company is required by the law of its place of incorporation to hold an annual general meeting and to prepare a balance sheet. Otherwise, the foreign company will be preparing its balance sheet in accordance with the Singapore Financial Reporting Standards. A breach of the financial reporting obligations currently attracts a general penalty of a fine which is not exceeding $1,000 and a default penalty. Going forward, foreign companies will be required to lodge financial statements which have similar components as those expected of locally incorporated companies. That would mean full financial statements. The test as to whether a company files financial statements that are prepared in accordance with the place of its incorporation has also changed. It would do so where the law of the place of its incorporation require the company to prepare financial statements in accordance with applicable accounting standards that are similar to the Singapore Financial Reporting Standards, or which are acceptable to the registrar. Otherwise, the foreign company would prepare its financial statements in accordance with the Singapore Financial Reporting Standards. There is also going to be an alignment of the penalties for financial reporting with those of local companies. Companies and which are in default, and the director or authorized representative who knowingly and willfully authorizes or permits default will be liable to a fine not exceeding $50,000. These changes to the financial reporting requirements will give stakeholders who transact with foreign companies a more comprehensive picture of the financial position of such companies, and will also be more consistent with information that is available in relation to local companies. I would like to highlight that the changes that I've just mentioned in respect of the financial reporting relate to the head office accounts of foreign companies. As you may know, the foreign companies are also required to prepare branch accounts in relation to their operations in Singapore, and there is no change to these requirements. Next, the expansion of the grounds for striking off for foreign companies. Currently, there are two grounds for striking off. These are where the registrar has reasonable cause to believe that the company has ceased to carry on business in Singapore, or where the registrar is satisfied that the foreign company is being used for an unlawful purpose, or for a purpose that's prejudicial to public peace, welfare, or good order. 3 new grounds for striking off of foreign companies will be added. The first is where the agent wishes to resign but is unable to do so because there's no replacement agent and the foreign company has failed to respond or act within a period of 12 months. Second is where the agent has received no instructions within a period of 12 months as to whether the foreign company intends to continue its registration. For these 2 new grounds, the reasons for the changes would be to help safeguard the sole authorized representative in the event that he wishes to end the relationship with the foreign company, but the foreign company is uncooperative. The last new ground for striking off that's being introduced is where a foreign company is left with no agent, and this could occur where the sole agent has died and the foreign company does not replace the agent who has passed away. The registrar may, in such a case, therefore intervene to strike off such a company if the situation has been left for more than 6 months. These are just some of the changes that have been made in the recently passed Companies Amendment Bill. For more information, you can refer to our website or to sign up for our news alerts by following the following steps. More information relating to our legislative reforms will be available by late November. That brings me to the end of my presentation. Thank you.